Nascimento present for Mr. Henry, who likewise is present. So I heard the evidence yesterday in the defense's pending motion to suppress statements of Corin Henry. State, am I still correct? There's no other additional evidence, witnesses, or testimony you would like to present as to that motion?
Correct.
And defense, there is no additional evidence, witnesses, or testimony you would like to present as to that motion?
We would like to present the testimony of defendant Mr. Henry
Oh.
for the limited purpose of what happened.
Okay, no problem. Mike, can you hear him over there? Do you want to do it? Yeah, Mr. Henry, just, you can stay right there with your lawyers, just speak loudly, okay, so everyone can hear the answers. Raise your right hand for me, please. You swear to tell the truth, whole truth, nothing but the truth?
Yes, sir.
Okay, you put your hand down. Please state your full name and spell your full name.
My name is Bortlen, C-O-R-T-N-E-N, H-E-N-R-Y.
Okay, sir, you may inquire.
Thank you, Judge. Mr. Henry, we just want to talk about what happened in the hospital on October 26, 2018. Do you recall driving to the hospital? You got to speak up, answer yes or no, so it's to happen.
Yes.
Okay. And then at some point, when you were brought to the hospital, were you placed into a room? When you were placed in that room, approximately how many officers were present?
5 or 6.
You know,
5 or 6.
And approximately, if you can remember, how long were you in the hospital prior to the 2 detectives arriving? You were there for a little bit before they got there.
Oh, wait, what did you say?
The detectives.
The text when we talked to?
And describe to me the room that you were in. Were you there by yourself or other people in the room?
It was like a private hospital room. We probably maybe like 4 different officers in the room. They had some outside of the room.
While you were in that hospital room, at any time were you placed in handcuffs?
Yes.
Do you recall who placed you in handcuffs?
One of the officers.
You're saying one of the officers. Are you differentiating officer versus detective?
Yes. One of the officers that were standing in the room.
Okay. And while you were in that room prior to giving your statement, was there always an officer in the room?
Yeah.
And at any time were there any officers in the doorway?
Yes.
What were they doing?
They were just standing there.
At any time prior to giving your statement, did you feel as though you had the ability to get up and leave? What do you think, in your mind, what was your impression that would have happened to you had you tried to leave?
They wouldn't let me go.
Prior to you giving your statement to the officers, the detectives, at some point were the handcuffs taken off?
Yes.
Why?
They wanted me to go and take, they wanted me to go to
The urine set? Okay. Was there a bathroom inside the hospital room?
No, they walked me.
Okay, you said they walked out one of the officers.
One of the officers, one of the deputies that was standing guard in the room, they walked me out, they walked me into a separate, bathroom, restroom outside.
Okay. And at that entire time while you were providing a urine sample, was there always an officer with you?
Yes.
And after you gave the urine sample, did you get brought back to the room?
Yes.
And at some point, there were 2 detectives that come, right?
Yes.
At any time during your interaction with those detectives, did they tell you to agree to? So then the first question.
Okay, cross-examination, go ahead.
Mr. Henry, you were taken into the hospital room for medical treatment, correct?
Yes.
You're aware that there is no urine sample in evidence, or collected in evidence.
As loud as you can.
No, I'm not aware.
You stated you were handcuffed. How long were you handcuffed for?
And most of the time I'm there. And the room was
So you were handcuffed for over 2 hours in that room, which you're testifying to.
yes, until I'm there.
You say twice a day.
Until he said I can leave. So I could-
Did you ever try to leave?
No.
Did you ever ask to leave? Did you ever discuss with the nurses that you wanted to leave? I'm going to show you what's being marked as states. For evidence. Do you recognize this picture? Who's that a picture of? And where are you? Are you wearing handcuffs in this picture? Just find a new states B and evidence in states 2.
Any objection?
No objection.
Without objection, states B for identification is now going to be an evidence that states exhibit 2 only for the purposes of this hearing.
Mr. Henry, you agreed to ride with Detective Toyota after the crime scene? Where you said the crime occurred? Did you ride with Detective Toyota, who testified yesterday,
Yes.
out to where you said the crime scene occurred?
Yes.
And you were seated in the front seat with him?
Which I'm gonna check, it's outside the scope.
Well, it is outside the scope, but over the defense's objection. Go ahead, sir, you can answer the question.
You did not ride with Detective Toyota?
I didn't ride the front seat.
You were in the back seat. Okay. And at the end of your interviews with the detectives, they offered you a ride home, correct? They did not offer you a ride home? And they did not give you, law enforcement did not give you a ride home? No further questions.
All right, based on that, any redirect?
So just briefly on the photo,
Yeah, let's go for it.
Mr. Henry, this photo that you were shown of you in the hospital, do you recall pictures being taken of you?
That moment.
Do you recall the officers taking photos of you? Was this taken before or after the handcuffs were taken?
Objection, Your Honor, I said it doesn't call for this specific.
Hold on, over the state's objection. Go ahead, sir, what's your answer to that question?
That was after
You said you recall some photos being taken. Those photos that you recall being taken, were they taken before or after the handcuffs were taken? After. No further questions.
Based on that, any recross? Mr. Henry, I got a couple questions for you. You didn't get arrested that day, correct?
No, sir.
How'd you get home?
Family friends and people.
Someone came and picked you up at the hospital?
Yes, sir.
And do you know what the time period was between that day and when you actually did get arrested?
That was October 26th. I was arrested January 28th.
All right, state, based on my questions, do you have any additional questions? Defense, based on my questions, do you have any additional questions?
No, Your Honor.
Okay. Defense, any additional evidence, witnesses, or testimony regarding the motion to suppress?
No, sir.
Okay, so it's just argument. So, defense, it's your motion, so when you're ready, take your time. Your argument in support of your motion to suppress, and I assume you want to suppress, well, I heard, which I think is contained on State's Exhibit 1, for this hearing, there's 2 statements. There's a longer statement that's about 40-something minutes, and then there's a very short one, which is like 2.5 minutes. You want to suppress everything? Okay, go ahead, sir.
It was not Miranda, as we know. I think the state was sticking to that. But what the issue is obviously, he was not at the police station. It's an issue of whether he was in a situation where he should have been Miranda. Whether the interrogation, as it were, constitutes an interrogation, whether or not it's custodial. Now, the defendant, the police had a shooting. We heard the testimony that a car arrived at the hospital with 2 bodies. Mr. Henry was driving the car. 2 bodies were taken into the hospital. Mr. Henry was taken to the hospital. And he told the nurse or somebody that was there that there was a drive-by shooting They explained to him where it happened. We know from what the detectives testified, other police people, personnel that were present and talked to Mr. Henry, then went out and walked the scene, canvassed the scene, looking for evidence of a drive-by shooting. They were unable to find evidence of the drive-by shooting, and the detectives came and talked to Mr. Henry. You've heard the tape, and I just want to quote from this transcript of it. The defendant is confronted with, as he said, the police corroborated there were at least 5 or 6 cops in the room, everybody around him. He was in a situation where he's, I'm gonna call it a custodial situation when we get to that point. But at any rate, the statement was, the defendant is confronted with, Bortlen and Miranda. Hey, Henry. Hey, man, how you doing? What's up, man? How you guys doing? Hey, my name's Detective Bortlen, and this is Detective Mark Miranda. We're here to talk to you about what happened, okay? Listen, you need to be straight up with us and tell us what happened here. My understanding, you told these officers something, but the evidence doesn't show that happened right here. That's confronting the defendant with something that's implying I've already said he committed a crime there. He was lying to the police. So we know that they're confronting him with evidence of falsehood. Should he have been Miranda, because the rest of the statement is what they're using to formulate the rest of the case. And I would submit to the court that the police had a duty to Miranda under that situation. They formulated, they have a crime, there's no question a crime committed, occurred. They called it crime scene. The scene at the hospital was taped off. It was an active crime scene. Half the Miramar Police Department were there. 5 or 6 people were guarding him. He's in a situation where any person would feel they were not free to leave. He's in a hospital where people, he said there were 4 in the room with him. The detectives corroborated there were a bunch of policemen with around him. Was there a duty to Miranda? I submit to the court that in this situation, the defendant was, well, quoting from Hunter, Miranda warnings are required when an individual is undergoing custodial interrogation. As this court, this is the Supreme Court, as this court has explained, a person is in custody if a reasonable person placed in the same situation to his or her freedom of action is curtailed to a degree associated with the actual arrest. The proper inquiry is not the unarticulated plan of the police, but how a reasonable person in the suspect's position would have perceived the situation. Would a reasonable person in the situation of Mr. Henry have felt like he was not free to leave? Would he have felt like he was under arrest? The answer is obviously yes. He's there, some crime occurred. He is in a situation where the police are telling him they don't believe what he said happened. They made it clear that they think he's lying to the police. How would a reasonable person perceive the situation? You're in a hospital bed, you have policemen all around you, you're being accused of lying to the police. Would a person perceive the situation as one where they're free to leave? I submit to the court on the totality of circumstances, they would not. I concede the cases state that a hospital room is not necessarily the equivalent of a police station, but it's not the place where the inquiry occurred. It's how the inquiry occurred and what the situation is, how the suspect perceives it. Any reasonable person, it's a reasonable man's man, as to whether a person will reasonably believe they were in a situation.
I'm sorry, I apologize, just pause 1 second. This is Martin. All right, Mr. Henry, I apologize. That wasn't regarding a medical issue, I wasn't taking the call. I apologize, go ahead.
I can go to Russ versus State, which is, court, which they relied on it so heavily in its motion because it was a hospital situation. The, court stated, quite correctly, police are not required to give Miranda every potential suspect. Miranda warnings only apply in custody investigations, court cases. Then it goes on to say the reasons for Miranda warnings at this stage because interrogation and certain custodial circumstances inherently coercive. Statements made under these circumstances are inadmissible unless the suspect is specifically warned of Miranda rights until he decides to waive those rights. And then it says for Miranda purposes, custodial question interrogation means question initiated by law enforcement officer after a person has been taken into custody or accordingly is otherwise deprived of his freedom of action anyway. The determination of whether a person is in custody for purposes of Miranda is how a reasonable person in the suspect's situation would perceive his circumstances, relying on Yarborough in those cases. A person is in custody, quoting from Hunter, a person is in custody if a reasonable person in the same position would believe that his or her action, freedom of action, was curtailed to a degree associated with actual arrest. And I quoted that before. And that's the situation we have here. The defendant is in a room. He is confronted by the police that they don't believe what he's telling them. That he's lying to them and they have to come clean. And then he's not Mirandized, he's surrounded by a bunch of police. He goes to the bathroom, he has police taking him to the bathroom. He's in a room where the police agree he's surrounded by police. They said there's a bunch of police, but 4 or 5 sound reasonable from what the defendant is saying. They're consistent with what already testified to. It's how many police are here. He's in a room, it's a confined place, he's got policemen around him, and he's confronted with evidence that he's lied to the police. Should he have been Mirandized? Absolutely. It's a statement that is going to be used against him in the obstruction case or accessory case. He should have been Mirandized. I think under the circumstances testified to as to how this occurred, the defense will entitled to Miranda warning under all the cases given. Thank you.
State.
Yes, Judge. Starting with Mr. Henry's testimony, he's clearly not being forthright with the court. As Detective Cox, or Officer Cox testified to, when he first got to the scene, Mr. Henry was sitting outside on a stone bench when he went over and asked him what was going on. When he is questioned in the room by the detectives, they testified that he is not handcuffed. In the photograph, he is not handcuffed. Detective Toyota takes him on a ride. If he was really a security risk, if he was really somebody they thought was a suspect, Detective Toyota never would have taken him on that ride, and they never would have offered him a ride home. That offer for the ride home is at the end of that reporting, where they say, like, we're gonna make arrangements to take you home. He was not a suspect. As the officers all, excuse me, the officers all testified, they thought he was a victim. He was receiving medical treatment because, as the defendant stated, he was among the people being shot at. So when we look at whether something is custodial or not, it's the Ramirez test, as outlined in Ross, which is the manner in which the police summoned him for questioning. He was not summoned. He brought himself to the hospital. The hospital was a crime scene. There were officers there, crime scene was there, they were processing the vehicle, they were processing the deceased, they were processing for evidence, potentially evidence physically located on Mr. Henry as a victim. The fact that the court heard the purpose, place, and manner of the questioning. This questioning was non-confrontational. He's not confronted with any evidence. They're not saying, you know, we found bullet casings, not saying we found GSR. The confrontation is, we don't think this happened where you said it happened. And if you look at the transcript, you read the transcript, you can see that, because on page 9 of the transcript, they're like, look, here's a crude drawing. Did you guys get off the ramp here? Did you drive past the Chick-fil-A? They're trying to figure out where this happened. As I think two of the officers joked, we were trying to figure out if we even had jurisdiction over this case, depending upon where it actually occurred. There were not 5 or 6 officers in the room. That never happened. What the officers said, testified to, is that there were officers around, you know, nearby, and there were, because this was a crime scene. There was an active shooter loose, based upon what Mr. Henry told police, because he was a victim of a drive-by, which means somebody is driving around shooting up vehicles. So of course police are going to respond to that. But he's not confronted with any evidence of guilt, and even if he is, of course, considering that, as I cite to in, Pitts, which is very parallel to this case at the end of my first section for issue 1, is even if they are confronted with some evidence of criminal activity, that does not necessarily transform it into a custodial interrogation. He's not confronted with any evidence of him committing a crime. It's just, did this happen where you say it is? And when we look at the entire context of the conversation, the tone and manner, this is not an aggressive confrontation of him being a suspect. This is, tell us what happened. Where's the location? Who are the victims? What, did anybody have a beef with you? Are you posting on social media? They're trying to figure out what happened, what is going on, the basics of the investigation. And I believe all 3 witnesses testified, we believe he was a victim at the time of that. It's a reasonable person standard. The fact that he is having, you know, that they're documenting his injuries, that's normal in nearly any crime. A victim of domestic violence is going to have their injuries photographed. A victim of domestic sexual battery is going to be transported to the sexual assault treatment center for potential examination. And they have the right to refuse, which is what the officers testified to. Had he wanted to refuse, we would have abided by that. There's no evidence, pardon me, there's no evidence supporting that this was a custodial interrogation or ever transformed into a custodial interrogation. Miranda warnings were never required for this because, as the officers testified to, at the time that they were questioning him, they believed Mr. Henry to be a victim of this. That's all I got.
Thanks, I'll give you the last word. If you guys want.
But if I may, I have to disagree with the statements. I do think that the beginning portions of the transcript were replete with instances of the detectives confronting Mr. Henry with what they believe evidence of him lying and not telling the true story of what happened here. We see it in the second question. First question is this Henry, but the second question is the evidence doesn't show that it happened there. You lied to us, you're not telling us the truth. If you want to page 3, you see them confront him on the bottom. Here's the hard part. We're having a real hard time trying to understand is that we shut down the entire area. We had officers on the shoulder walking out. They didn't find as much as 1 shell casing. They go on, but they end with nothing to what you said adds up. You're lying, Mr. Henry. You're not telling us the truth. We think there's more to this. Later on, they go on, we should expect to find evidence here. And they're describing that to him. Right now, there's nothing, okay? I kind of think I know what happened because I got information that something else happened on the east side of the city. But you know, it sounds similar to your thing, but you need to tell us. You need to be straight up with us, okay? Next question. You're doing your friends a disservice. So repeated examples of them telling him at the beginning of the statement, what you said to us is untrue. You are lying to us. We've done an investigation. The evidence that we have doesn't match what you're saying. We're confronting you now with the lack of evidence to support your story. So clearly, they're confronting him with evidence of his guilt or involvement in some way in either the accessory after or the murder itself. And as far as arranging for a ride to go home and being in a ride along with the officers, that matters not as to what the environment was when Mr. Henry gave his statement in that hospital. He has testified to this court, he's not feel he was free to leave. This court's gonna evaluate that based on a reasonable person standard in his position. Whether or not he's in handcuffs when the statement occurs, again, matters not. There are officers, he was not free to leave the hospital room, he go to the restroom. I think it's easy to understand that had he stood up and walked out of the hospital, they would have stopped him. He had been there for some time before the statement occurred. They were collecting evidence, because it was a crime scene, including evidence, GSR from his hands, taking his clothes, things of that nature. Things that a reasonable person would not understand to be happening to a victim of a crime, or someone who may be a suspect of a crime. And at the very end, Judge, whether the officers have testified they believe him to be a suspect or not matters not, as the case law tells us. In Stansbury versus California, 511 US 318, the police officer's subjective view of the individual is not bearing on whether or not the person believed they were in custody, whether they express it or not to you. It's what happened to Mr. Henry that day, and was he reasonable in believing he was not free to leave? Was his physical emotion, or was his right to decide what to do next curtailed by the action of the officers? And we would submit that it is clearly, if you evaluate it just in the vacuum of that room prior to the statement. Thank you.
Okay, listen, although normally the best practice would be for me to give you all a written order on there, I'm just gonna go to the bench, because of the time constraints that we're under here. We set the trial, we're gonna commence the jury selection next Wednesday. So regarding the defendant's motion to suppress, statements of Corin Henry, number one, I find witness Jordan Cox to be credible. I find witness Stephen Toyota to be credible. I find witness Mark Moretti to be credible. For the most part, I find witness Courtlen Henry to be credible, except maybe as this handcuff issue. I just don't know. There's no evidence in front to the contrary. So let me put a couple things on the record right up front. Number one, it's clearly interrogation. Okay, there's no issue about that. They're asking him questions like, did you fire a gun that day? Did you have a gun that day? All right, those are questions that are meant to elicit or could elicit an incriminating response. It's clearly interrogation. That's not an issue. Number two, certainly the best practice would be for homicide detectives to just advise the person of his rights. And were they to advise him of his rights, then we don't have to go through this 2-day procedure. And I'm not called upon to make this determination. But for whatever reason, law enforcement doesn't really seem interested in doing that on a lot of these cases. So I have to make this determination. So really, the whole ball game here is whether he's in custody. And I'm familiar with the case law that the state cited. I've reviewed it again. I'm familiar with the case law the defense cited. I reviewed it again. The bottom line is, I don't think he is in custody. And I'll put the reasons why on the record. Let me also make this clear. If I had a photo in front of me, and I don't care where it was taken, if it was taken outside in the bay of the emergency room entrance, if it was taken inside the hospital, I mean, there's video cameras all over these hospitals, maybe not the treatment rooms, but if I had any picture or any video of anything anywhere that at any point in time Mr. Henry had handcuffs on, I'd probably feel differently about this, but I don't. I have nothing that supports that in front of me, number one. Number two, they did in fact let him go. Number three, I think this defense is trying to give law enforcement too much credit. This is just a few hours after a double homicide occurs. And they're trying to, I guess, infer some nefarious purpose on behalf of law enforcement, that they knew Mr. Henry was a suspect, that they knew Mr. Henry was going to be charged. This is the perjury trap that the defense relies on or mentions in their motion. I don't think they had any idea what had happened up to this point. It was just a few hours after a double homicide. They're just trying to figure out what's going on, to the point of putting Mr. Henry in a car and driving him to the scene that he says where this took place, because they're trying to figure it out. So they had no idea what was going on. They certainly didn't have any idea that Mr. Henry was going to end up being a defendant in this case. That seems to be corroborated by the fact that he doesn't even get arrested until more than 3 months after the fact. If he had ever asked to leave, I would feel differently about this. If he had ever told any witness anywhere that he didn't want to talk to them anymore, I would feel differently about this. He did no such thing. Again, based on the totality of the circumstances, I'm supposed to determine this. I listened to the questioning. I agree with the state in this part. It wasn't what I would call an intensive or aggressive questioning by the detectives based on their tone of voice and based on what they're trying to find out. They actually kind of go out of their way several times to say, listen, we don't care if you had drugs. We don't care if you were committing another crime. We don't care about anything else. We're homicide detectives. We're trying to find out what went on in the homicide. As to the defense's argument that there is a large police presence at the hospital, I would suspect that if any person in this room drove up to the hospital right now with 2 dead bodies in their car, there would be a very large police presence that would respond almost immediately to that location. So that in and of itself doesn't really sway anything in my mind. I think any reasonable person would have to expect that you drive up to the entrance of an emergency room with 2 dead people in your car who were shot, that you're going to be confronted with a rather large law enforcement presence almost immediately. So again, based on the totality of the circumstances, where I do find that the best practice would have been to advise him of some Miranda rights, and where I do find that this was in fact interrogation, I do find, based on everything that I've put on the record, that Mr. Henry was not in custody. Therefore, respectfully, the defense motion to suppress both the statements is going to be denied. I'll enter a written order that reflects such. If and when we arrive at the part of trial where the state tries to introduce this, that would be over the defense objection, which I would consider to be preserved, renewed, and contemporaneously made. So I'll enter a written order as to that. Next, state, you filed a state unopposed motion for relief from trial order dated July 8th, 2024, and that was for the purposes of filing a motion in limine to exclude the testimony of potential witnesses Michelle Boutros and Christine Bradley. I think you all told me yesterday the defense has no objection to your unopposed motion for relief from the trial order to file the motion, number one. And number two, the motion in limine is otherwise moot because they don't intend on calling Michelle Boutros or Christine Bradley as witnesses. State, is that correct?
I believe that's still correct.
That's
Defense, is that correct? Okay.
The way it stands, I don't believe we would.
All right, so.
And should that happen, we can address it.
Okay, well, as far as the motion for relief, just to file your motion, that's granted, and I'll enter a written order as to that. Regarding the state's motion in limine, I'll defer on that, and I'll enter a written order. And if no one calls them as witnesses, it's not an issue. And if someone's going to call them as a witness or wants to, I'll address it and give you a ruling on that. And if that requires me to send the jury out and even take a proffer from either one of these witnesses, it doesn't seem like it's going to be too long in time, but I'll take a proffer from them if I need to outside of the presence of the jury before I make a ruling. Although I can tell you, I have no policies, but as a general rule, credibility of witnesses is always at issue. So if we're talking about the credibility of a witness in the case, a witness that one side or the other side needs the jury to believe to have the jury believe their version of the facts of the case, then I would probably be hard pressed to say that I would prevent any witness testimony in front of the jury in that regard. But I'll enter all 3 of those orders today. Ms. Wilcox, this one on top is granted, the reasons stated on the record, and then the motion limiting underneath is deferred for reasons stated on the record.
The motion hasn't actually been filed yet. You just have to file.
Oh,
the
you're gonna
motion
file
for
it.
relief.
I'll
So
consider it.
I'll file it today, but we won't.
Do they have a
send it
copy of it?
anything.
They already have a copy?
Yes, there you go.
All right, so I'll consider the state's motion in limine based on my ruling granting the relief from the trial order filed today, which is September the 5th, and I will defer ruling on it based on what I already put on the record. State, is there anything else that you need me to do for you regarding Mr. Henry today?
Not today, Your Honor. Thank you.
Defense, is there anything else that you need me to do regarding Mr. Henry today?
Not today. Thank you.
So Mr. Henry's going to keep a couple dates. Number one, next Tuesday, September the 9th at 1:30 p.m. We'll call that a trial status. So the record is clear on this. If there's going to be some sort of resolution, it has to be Tuesday afternoon. I can't take it Wednesday morning because I'm going to have the jurors here. There's simply too much human resources involved with this. And if Mr. Henry's case does resolve, and again, to repeat what I said yesterday, it doesn't matter to me whether it does or it doesn't. I have a couple other murder trials that are in line with in-custody defendants, and I would use those jurors.
Not bring him here at 5 in the morning.
Yeah, just sign it. We'll give you a blank order. Just fill it out that says I need him here Tuesday, September the 9th at 1:30 PM. 1:30 PM. Mr. Henry, Tuesday would be the last day you're dressed like that. If we go forward to the trial on Wednesday, I need you in your trial clothes, okay? Dress for trial on Wednesday. We're gonna have jurors here Wednesday. And then he has, besides the September 9th date at 1:30, he keeps his trial dates for September the 10th at 9 o'clock.
I don't need an order for 1:30, they all open it for lunchtime.
However you want to write it up.
Yeah, when it's 1:30, they usually bring on the afternoon bus.
Yeah,
They
that's
bring-
what it is.
Yeah.
Absolutely.
They'll walk over,
Yeah.
I'll take care of it. When?
Yeah, just,
When I need it.
okay.
Thank
Okay, very good. I already sent you preliminary jury instructions. For the benefit, Mr. Haddad might be the only person I haven't done this with. Mr. Nascimento did it some years ago, but I bet he remembers. And Ms. Collins did it far more recently. But on Wednesday, the only thing I'm gonna do is march in 5 panels of 50, 50 at a time. I'm gonna have the same trial schedule without the case information sitting in each chair. So they're gonna be told that I need them from September the 10th through up to and potentially October the 10th, Friday, October the 10th. There's 2 court holidays in there, Tuesday, September the 23rd, and Thursday, October the 2nd. I'm gonna talk to each of those jurors regarding their ability to serve only as to the statutory reasons that I can excuse them. Regarding the schedule only, the lawyers won't have to say anything on Wednesday, September the 10th. Once I get 60 people is the maximum that I can seat in here for a jury panel. So if and when we arrive at 60 people that tell me that they can serve, they're gonna be numbered 1 through 60. They're gonna come back Thursday morning. When you all leave here Wednesday, you will have a copy of my questionnaire that they have filled out. It's gonna be numbered 1 through 60, and a seating chart, so you know where each of those jurors are gonna sit. And then starting Thursday morning, we are only gonna address those jurors by their numbers. I have lanyards numbered 1 through 60. Mr. Court Deputy is gonna pass them out every morning. He's gonna collect them every afternoon when we're done with the jury selection process. So we're not gonna refer to anyone's name on the record. State, you'll know the names because you'll have the list. Defense, you'll know the names because you'll have the list. And I know the names, but again, pursuant to the pretrial orders that I've already entered, everyone's continued to be ordered. We're not gonna disclose those names to anyone else. If any of the jurors' names are otherwise released to the public in any way, shape, or form, because I've already ordered the clerk not to do that as well, I am going to conduct an investigation and determine where the names are released from. And if I find out that someone has violated any of those pretrial orders that I entered, I will conduct an indirect criminal contempt proceeding immediately. So I would highly hope that everyone will comply with those orders. We're only going to refer to the jurors by number starting Thursday morning. I think that's it. State, anything else you need me to address before we recess until Tuesday at 1:30?
No, you aren't.
Defense, anything else that you need me to address until Tuesday at 1:30?
No, sir.
Okay, so I'm going to see Mr. Henry next Tuesday, September the 9th at 1:30 PM. Division, Ms. Wilcox, that concludes Division FT for today. Division FT is going to be in recess until Tuesday.